Okay, welcome everyone. Good evening and welcome to the State Bar of Montana Citizens Law School. I'm Lindsay Simon. I am a member of the State Bar's Law-Related Education Committee and an Area F Bar trustee. So our topic tonight will be criminal law, which I'm excited about because I think this is the area of the American legal system that the general public is probably most familiar with, given the popularity of crime-based television programs and true crime podcasts, and maybe even some personal experience. I know there have been many times for me when I've told someone I'm a lawyer and they immediately ask me if I'm a prosecutor or defense attorney, and they always seem slightly disappointed when I tell them I'm just a boring civil attorney. So I'm going to start with an introduction of the presenters we have with us today. We are lucky to have someone on the prosecution side and someone on the defense side of criminal law practice. I'm going to start with our prosecutor, Ed Hirsch. Mr. Hirsch is an assistant attorney general with the Montana Department of Justice. He works in the department's Prosecution Services Bureau as a traffic safety resource prosecutor. In his current position, Mr. Hirsch educates law enforcement officers and prosecutors around the state on traffic safety issues, which includes DUI prosecutions. And prior to this role, he has over a decade of experience as a trial prosecutor as well. And our criminal defense side is Public Defender Brian Smith. He is the Public Defender Division Administrator for the Montana Office of the State Public Defender. Mr. Smith has devoted most of his nearly 30-year career to criminal defense work before taking on the role of the OPD Division Administrator. He previously spent 8 years as an assistant public defender for the OPD's Missoula office, and then spent 6 years practicing as a private criminal defense attorney as well. Mr. Smith served for several years as a State Bar of Montana trustee, and he was bar president in 2021 to 2022. So originally, if you saw the advertisement for tonight's presentation, we were planning on having Missoula private criminal defense attorney Nate Holloway of Holloway and Hulling join us as well, but he's currently in the midst of a jury trial and thus unable to join us. But I think with Mr. Smith's private practice experience, we have all corners of criminal practice covered here tonight. And so with that, I'll turn it over to the presenters for the presentation. And we do have a Q&A function as well on this Zoom call. So if you have any questions, feel free to enter it in the Q&A, and I will try to jump in and present those to the presenters throughout the presentation.
Sounds good. I think, Brian, why don't you start with your portion, and then I'll jump in after you.
Evening, everybody. Thanks for being here. I think the introduction very nice. The Public Defender's Office is throughout the state of Montana. I think just a couple facts about us. We do basically cases throughout the state of Montana, civil and criminal, where a person is facing a loss of some sort of right. Usually, and in this case, we're talking about a criminal case, ordinarily facing the loss of liberty. We have offices in 15 different cities. We've got a couple of small satellite offices. We handle about 30,000 cases a year, and have about 300 people employed. So Ed's going to introduce himself as well, and we're going to talk generally and specifically, and I think the case we're going to talk about is a DUI case. I'm just here to support Ed. Ed is the expert here. Give him the other side, or give you the other side of the coin and the defense. But thanks for being here. We do want you to ask questions. Please ask questions. If we can provide information you're interested in, that's certainly what we want to do. So take it away, Ed.
Yeah, I'll introduce myself a little bit. I've been a prosecutor in the state of Montana for, I think, about 12 years now. I am your TSRP. You all know what that stands for. Say it along out loud with me at the same time, because you know what it stands for. Traffic Safety Resource Prosecutor. You don't know what it means because it's kind of a nonsense acronym. The idea is that, okay, here's the reality about the criminal law system. Public defenders, law enforcement, prosecutors, it's tough work. It's a tough job. And the reality is the turnover rate for these roles is pretty high. The idea with what I do is kind of be a centralized hub to be kind of a source of institutional knowledge of all things DUI in the state of Montana. So I'm constantly fielding calls and giving trainings for law enforcement, prosecutors, occasionally judges, occasionally members of the public. And that is really my bread and butter. My history really has been specializing in both DUI cases and domestic violence cases. Today we're going to we've got like 60 minutes to run through criminal law, which, as you can imagine, is a bit of a big topic. I don't think we're going to get through every little nook and cranny of criminal law, but hopefully we'll just give you a big, broad overview of the thing from start to finish. As you will notice, unfortunately, if you ever do aspire to join either prosecution or defense and work in criminal law, you do have to go to the same barber as Brian and I, and then we have the issued glasses that we all have. So that's why we look the way we are. Obviously, Brian and I would actually have long, beautiful
And an issue haircut.
We go to the same barber. So anyway, I think we'll start with, how about we start with the role of a defense? I'll start with the role of prosecutor, and then Brian, you do the role of defense attorney. How's that sound?
Sounds good.
Love it. So the role of a prosecutor is a bit aspirational. It's right. The technical definition or the rules that we're given is our role is to represent the people of our jurisdictions impartially and independently as legal counsel during the charging, prosecution, sentencing, and appeal of criminal offenses. Our ultimate ethical mandate, what we're required to do, is seek justice. Okay, what is justice? Justice is different for all of us in our different perspectives. I mean, the reality is everyone in the system, prosecutors, defense attorneys, judges, we're all fighting for justice in our own way. We just have different perspectives on it. Prosecutors do have some higher ethical burdens that are we held to. The way I said that implied like defense attorneys are less. That is not the point. The point is that we have extra professional requirements that we need to do when we're doing our work, because we don't represent individuals, we represent the people. And that means we have ethical obligations to the victims of crime. We have to keep them informed. Now, they don't dictate how we objectively need to treat a case, but certainly we need to keep them informed about what's going on, having conversation with them and explain the process and involve them as much as we are legally permitted to do, while also making sure that we're not having like malicious prosecution. You don't want a victim driving the bus on where justice for society goes. That can potentially have problems. We also have ethical obligations to defendants. Our job and our ethical mandate is we cannot violate the rights of defendants. Just because someone has committed an offense, if we've gotten there in an unconstitutional way, then we can't take advantage of that. It just is what it is. Likewise, we have ethical obligations to the courts and the people of our jurisdiction. Big picture, it's not like TV. I'm sure many of you watch Law and Order, SVU, et cetera, et cetera, et cetera. Prosecutor rolls down to the crime scene of the homicide, flashes a badge, is like kneeling down next to the detective, looking at blood spatter. It's not like that. We don't do like that. It is not like that at all. Very occasionally, some prosecutors on very specific cases may show up at a crime scene to help fill out paperwork and make sure search warrants are done properly and searches are done correctly. But it's not like that at all. Really what we do is we review the charges, investigations by law enforcement, and then carry that case through the criminal justice. That's kind of the huge macro level overview of prosecutors. I should have also started with this. I'm an attorney, so I have a disclaimer. These opinions are my opinions alone. They do not represent the opinions of my boss's boss, or my boss's boss's boss. So if anything I say offends you or is incorrect, they are my opinions. Please don't get me in trouble. And that's kind of the role of a prosecutor at the macro level. Brian, role of defense attorney.
I would ditto Ed's disclaimer. The opinions are my own. We both work for the state. And so essentially we roll up to the governor, both of us. So again, our opinions are ours. Please take that for what it is. But so I thought about the role of a defense attorney, and I think Ed would agree with me. The roles of defense and the prosecution, we could spend days, we could spend hours. It's a whole series of pleas. And so there's a quote from a justice in a dissent in State versus Hightower that I think really sums up what a defender is. And I'm using the public defender in this quotation, but it does apply to the defense as well. Public defenders stand alone, armed only with their wits, training, and dedication. Inspired by their clients' hope, faith, and trust, they are the warriors and Valkyries of those desperately in need of a champion. Public defenders, by protecting the downtrodden and the poor, shield against infringement of our protections, and in reality, protect us all. And that's what I would say about the role of the defense. We're there to make sure it's done right. We're there to make sure that the defendant, our client's rights are protected. And by doing that, we are protecting the people who are not in the court, the people, everyday citizens who are walking down the street. The protections that you have are the result of people protecting those in court. So that's what I would say the role of defense attorney is.
And if you wouldn't mind adding a tag on that, like from the prosecutor perspective, like that is so true, right? Because if there wasn't someone pushing back on potential constitutional violations or something like that, law enforcement would just be left to kind of regulate themselves. And the reality is sometimes everyone in this profession loses sight of kind of the bigger picture. And it's important to kind of have that safety net of pushing back and making sure that we're doing it right. And when sometimes a defense attorney does get evidence tossed out because of constitutional violation, because of the hard work of a defense attorney, that teaches law enforcement and prosecutors, hey, there was the line and you crossed it. Now we know going forward, well, that's the line, you can't cross it. So it's well said, Ryan. I love that quote.
We work in a human system and humans make mistakes. And really we need to do it right by the people who are in the justice system, the defendants and the victims and everyone else. And really we both play the role to make sure it's done right. And if it's not, if we don't have these players in the system doesn't work. And it may not be the best. I mean, there are flaws, but it is probably the best. It's the best we've thought of so far.
Let's jump into kind of going through this, where we're going from here. We're going to kind of walk you through the life of a case. We have picked a very generic DUI. We could have picked something fun, sexy, exciting, homicide, things like that. But the reality is the vast majority of criminal offenses that go through the system are, quite frankly, pretty humdrum, ho-hum, not the most exciting of cases, but they're still important. We have picked a case. It's actually one of my cases from maybe 6 years ago. It went to jury trial. We've changed the names. We've you can't really identify the person via the little snapshots we have in the thing. We're not going to use their name. And I want to preface all with this is not a bad person. This is not some villain, not some, hardened criminal. It's literally a young woman who probably made a maybe one-time lapse of judgment, and ended up being caught and being held accountable for it. We went to jury trial, and the jury did ultimately find this individual guilty. And so we're going to kind of talk through a little bit of the facts and kind of walk you through what this case will look like as it's going through the system. So I'm going to share the screen here. Hopefully this will work. And we are off. Great. It's just a generic driving under influence offense. I wish we could deep dive into DUI. I love DUIs. It's my bread and butter. I spend all day, every day thinking about it constantly. But we're just going to race through this as best we can. Okay, so background information. We, in the criminal law, when we're talking about offenses, we talk about what are called elements. And kind of as an analogy, think of a cheeseburger. I'm sure many of you eat cheeseburgers, and I'm sure many of you have opinions about what should go on a cheeseburger. 2 all-beef patties, special sauce, lettuce, cheese, pickles, onions, and sesame seed bun, right? Big Mac. I love a Big Mac. But at the end of the day, technically, the bare minimum ingredients necessary for a cheeseburger is a meat, bun, and cheese. 1, 2, 3. That's it. When it comes to the criminal law, we have these things called elements, and those are kind of our meat, bun, and cheese of criminal offenses. They are the necessary things required that the state, the prosecutor, needs to prove beyond a reasonable doubt at trial. Now, we may like to know the other things. We may not like to know that, well, they weren't drinking just whiskey, they were drinking whiskey plus beer. or it was a blue car versus a red car, but very rarely are those necessary elements for a crime. They may inform the crime, they may support that this is more likely to happen or not, but at the end of the day, the elements are the essence of the criminal offense. So for a DUI, generic garden variety DUI in the great state of Montana, there are 3 elements the state must prove. The state must prove the defendant was driving a vehicle upon the ways of the state open to the public, and for our purposes today, that just means road. It's a more complicated definition, includes parking lots, includes parking areas. It could potentially include driveways, things like that. We're not going to dig into it. And then third, the defendant was under the influence. I think, Brian, you'll agree with me that the vast majority of DUIs kind of hinge on this final element, the under the influence element. Is that fair?
Yeah. And I think you're going to get to what that means.
Yeah, 100%. Simplifying it, it means that as a result of taking the body alcohol, a person's ability to safely operate a motor vehicle has been diminished. Diminished safety. That's really the threshold. Was there diminished safety because of alcohol? There's no actual injury or damage. Oh, what was that?
No matter how slight.
Yeah. It's as a prosecutor, we like that burden, and I guess as a member of the public, I also appreciate it. If alcohol is affecting your ability to safely drive, then I don't want you on the road, but it is, right? It kind of puts sometimes defendants in a tough spot with that definition, I think.
Yeah, I would say no DUI trials or cases are ever about, it was only a little bit. It's if the prosecutor's going for impaired, the defense is saying no, not under the influence, not impaired, not even to the slightest. That's a lot of what the argument's about.
100%. You've probably heard the term legal limit. I hate that term because, at least in the great state of Montana, it's a misnomer. It's not technically accurate. There is a legal limit with a separate offense. We're talking about a DUI. There's another offense that's a flavor of DUI, a Diet Coke of DUI, if you will, that it doesn't matter if someone has diminished safety. If they're just at a 0.08 or more, it is automatically that offense. It's called a DUI per se often. But calling the legal limit is a little bit of a misnomer. I'm kind of getting in the weeds here, but long story short, what we care for this case is diminished safety. All right, here's the generic facts or basic facts. Overview of the case. May 26, 2017, so it was 6 years ago. Bozeman police officer Christy Odom, her maiden name was Cluin, observed defendant commit a minor traffic violation. Speeding. Speeding doesn't mean someone's DUI, right? There's no inherent reason why someone who is speeding would necessarily be DUI. Pulled her over, and then investigation ensued. Up at the car window, Officer Odom observed a bunch of kind of indicators of potential alcohol consumption. She started smelling the odor of alcohol coming from the vehicle. She started hearing that the defendant had some slightly slurred speech. It wasn't egregious, but it was a couple stumbling over words a couple times. And then defendant did admit to drinking. She actually said, "Oh yeah, I was coming from the Eagles bar, and if I recall correctly, she said she had 2 drinks." Brian, I'm sure, can vouch that most DUI offenders say they had 2 drinks. It's just kind of an ongoing thing in DUI law, but sometimes, not everyone, even if they're all mostly a good person, sometimes they maybe exaggerate or downplay the amount of alcohol they've consumed when they're talking law enforcement.
It seems silly, but a lot of people say 2 drinks.
2 drinks every time. Field sobriety tests were administered. I would love to deep dive into the science of field sobriety tests, but I don't have time. So we're going to simplify. Long story short, you can kind of think of them as like a roadside screening tool that officers can apply to help them make their assessment of whether or not someone is impaired. Now, there's all this kind of science that goes in.
Ed, can I back you up for just a second?
Absolutely.
The fact of drinking and driving is not the illegal part, or not what the case is about. It actually is legal to have a drink and to drive. It's just not legal to drink to the point where the ability to operate your motor vehicle safely has been diminished. So You can't admit to drinking. That's not the crime.
Yes, that is a great clarification, right? I kind of totally breezed over that. It's not, oh, she admitted drinking, boom, bing, bang, boom, we're done. No. In Montana, there is a threshold. You can drink and drive. It's just you can't be to the point where you have that diminished safety. So field sobriety tests are kind of like a roadside screening tool that officers use to assess whether or not or to what degree a person may or may not be impaired. They're not perfect. They're not flawless, but they're a decent preliminary screening tool that can be done roadside by most law enforcement.
It might be called stupid human tricks.
I've heard them called stupid human tricks. That is true. Long story short, they have a certain number of scored clues, basically observations the officer can make. And if there's a certain threshold of those scored clues, that result is consistent with someone being at or above a 0.08 alcohol concentration, that quote legal limit. So in this case, the first test, horizontal gaze nystagmus test. It's an eye test. I would love to dig into it, but I can't. Long story short, it has to do with involuntary eye jerking when someone has been consuming a very small subsection of alcohol or drugs. In this case, the officer saw a 6 out of 6, which means she saw all the score. The next one is the walk and turn. You've probably seen that. It's like walking down a line. There's more to it than that, but there's a potential 8 score. In this case, the officer saw 4 of 8. Now, 2 out of 8 is generally consistent with someone being in an alcohol concentration of 0.08 or more. So we've seen more than the minimum threshold here. Now here's where it gets interesting. Oops, well, that's out of order. The last test, the one-leg stand. The officer only saw 1 out of 4. Now, usually, you would expect to see 2 out of 4 if someone is at the 0.08 or more, which means the officer, as they're going through this investigation, finds a fact that is a little bit inconsistent with what they would expect to find, right? And so this happens. There's some fact that, well, maybe I've got this wrong. Maybe I've missed something. But when it comes to kind of making this decision, we look at the totality of the circumstances and we continue our investigation. There's an alphabet test, and then the defendant ultimately provided a breath sample of 0.118. Over that 0.08, again, legal limit. I don't love that term, but you know what I mean by that. So
we'll talk about the ABCs later.
Yeah, yes. The ABCs are not a validated test. They are just something extra that this officer did. So Brian can jump in on that when we get there. So right off the bat, officer observed a driving violation. Now, here's the problem though. The officer didn't get out their radar gun and hit him with a radar gun. They did what's called pacing, which means they kind of slowed their vehicle down to, well, sped their vehicle up to match the same speed as the defendant and paced with them. And you can see down here at the bottom is 32 miles an hour. That's approximately how fast the defendant going, but it's not nearly as accurate as a radar gun. So I'm sure Brian can attest, hey, well, there's an argument there that maybe this isn't as accurate as you would think. Next, we've got
miles an hour seems okay to me.
7's not that bad. It's pretty normal. You know, it's not a big deal. Next is at 1:18 a.m. The officer included in the report that, well, 1:18 a.m. heading from the direction of downtown Bozeman shortly before bar closing. Yes, someone coming from the bar shortly before bar closing, it kind of implies that maybe they had more than 1 or 2 drinks with dinner, but it's not definitive in any way. It's just another piece of the puzzle we consider in the totality of the circumstances. Next, we've got kind of the initial things the officer observed. There's the odor of alcohol. She had glassy eyes, but maybe she was tired. Maybe she wears contacts. Slightly slurred speech. Again, maybe she was tired. There's a lot of reasons, or nervous, that she could have had the slurred speech. We've got some admissions, the 2 drinks, and came from the Eagles bar. And then the field test. Before the field test, what's interesting, the officer didn't know this. She did not notice this in the field. She noticed it afterwards when preparing for trial on her video. Defendant kind of does a little stumble here while the officer's turned away and actually walking towards the front of the car. There's a little stumble there.
I would characterize that as confusion and a little stutter step.
A little stutter step. It's no big deal. Like I said, the eye test. We're looking for jerky eyes. And long story short, the officer observed 6 out of the 6 possible clues. So that generally would be consistent with over a 0.08 alcohol concentration. He was also swaying a little bit and had to keep being reminded. He kept doing this thing where you're told, hold your head still and just follow with your eyes and your eyes alone. But the suspect kept doing these, turning the head. Walk and turn. We can see a number of scored clues on this one. Not horrible, but there's certainly some balance, and the inability to walk on a straight line and touch heel to toes is a pretty good indicator of physical impairment. But then the one leg stand. There was some slight swaying. She only observed 1 out of 4 clues. That's potentially make you pause and think maybe we got it wrong. And then ultimately there was the ABCs. The defendant was asked to recite a portion of the alphabet from D as in dog to X as in X-ray. Brian, you want to walk through kind of some arguments with it?
So one of the things that prosecutors are going to rely on is that these have been peer reviewed tested, and these tests, this involuntary jerking of the eyes and this divided attention testing where they're telling you to walk a straight line but they're giving you instructions, or the one leg stand, are all reviewed and have studies and all of this great. They're just going to say these are our bread and butter. But when the officer adds their own test, which is kind of what the ABCs are, or uses a test that's not validated, they're opening themselves up to criticism of, like, you're just using another stupid human trick. Like, you've got to go dog, echo, foxtrot, right? I'm assuming that's what the thing is. Or you have them do their finger and touch their nose. And they're kind of based in a little bit of science, but everybody's kind of making it up. And so I was telling Ed earlier today, I'm like, they don't need this, right? And then when they do this type of testing outside the norm, it just gives us fodder to say, look, you don't necessarily believe in these standardized tests. You've got to use your own test. And I would have fun with this at trial, because this is not what it's supposed to be used for. And I think Ed would say, there's other things that they can use for indicative impairment. They're really just trying to get it right. That would be the prosecutor. I would be saying, there's a reason we have this test, and this doesn't meet those reasons.
And I'll just add on to that, right? There's also this perception of the officer just did one of these validated tests, the one leg stand, and the defendant didn't score the expected amount of clues. And then all of a sudden she's adding in this new test, which isn't maybe one of the validated standardized tests. And that kind of, you got to stop and think, like, well, what was the intent here? Now, obviously, I worked with this officer and I met with this officer, and her explanation would be like, well, I just was adding another test. It's in the manual. It's not validated, but it is in our training manual as an additional test we can try. And after the one-legged stand, I was just trying to make sure I got it right, So if she passes this one, well, then maybe I got the whole thing wrong. At least that was her perspective.
Well, see, that's what the defense would pick up on, is, right? Like, she has doubts. She has so many doubts that she's got to use some alphabet test. Jury, you should have doubts. This is not beyond a reasonable doubt. So, that would be the defense argument, is you're using this test to make sure that you're getting it right because you weren't sure. Yeah. Jury, you shouldn't be sure.
And finally, we do have a breath test, that's a tougher hurdle to get over for defense in this particular case. While the instruments are not perfect, and we don't, God, I wish we had time to dig into the science of it.
You mean the machine, not the instrument.
The machine, you mean?
Yeah, the machine. This not fail-safe, right?
Yeah. It is a common joke in the criminal law world with DUIs is a prosecutor will always call it an instrument. Defense attorney will always call it a machine, because instruments are precise and use data, while machines break down.
And we've got a question. So why does law enforcement do those tests? I'm stealing Lindsay's thunder. She was about to get to it. But maybe you can, I think we talked about it a bit, but if there's anything else you wanted to add as far as there's other tests, drug recognition, other things.
want to dig into that because that's going to open up a can of worms, and just with time, I won't jump into the drug recognition. But
Okay.
yeah, let's talk about why are we doing these road tests if we can just do the breath? Well, the reason is because at the end of the day, there's this thing, the Constitution, right? We have to have a certain threshold of evidence before we go to the next step of escalating to a breath or a blood test. And the field tests are really good at showing and demonstrating potential impairments rather than just a BAC, right?
Well, they're not under either, right? I mean, like, I think that's what you're saying, is that they're not under arrest yet. You know, this is, you know, that we're trying to still keep the person in the community. It's the least restrictive kind of procedure. Yeah, I think you were going to probably get to that.
Exactly. And literally, I've seen thousands of cases where, you know, I've seen thousands of cases over my career, but I've seen thousands of cases of other traffic stops where they get some initial indications of maybe this person might be under the influence, and they start the tests, and after one or two tests, they go, nope, I'm mistaken. All right, here's your no insurance citation. I was mistaken. Thank you. You're on your way. And it really is used as a screening tool to make sure we get it right before we escalate to the next level of asking for the breath test or potentially even a blood test or things like that. They are actually used to weed out people who are not impaired. The problem is you don't see those in a jury trial, because if we're here, we ultimately think that they were impaired, and generally they scored enough clues on it where we think this is probably someone who's not safe to drive.
That is one of the interesting things about perspective. People that work on the defense see the people arrested. People in the prosecution see the people who weren't necessarily arrested, or cops, officers, law enforcement. But the way we look at it is everybody got arrested. We're defending everybody. And I think Ed is correct. If we are intellectually honest, not everyone who gets pulled over gets arrested. Sometimes that's hard to logic through.
Yep, absolutely. Okay, that is the brief overview of the facts of our case. So you've got some facts to talk about. So how does this make its way through the system? I'm checking on my time. I think we're about good on time. What we've just described is the investigation. Generally speaking, law enforcement are going to conduct the investigation. Now, me as a prosecutor, I may assist in small little ways. I may help them with paperwork. I may help make sure the search warrants are online. I may do what's called in Montana an investigative subpoena, which is basically a type of search warrant that a prosecutor applies for a judge to get more evidence. But generally, we don't take active roles in the investigation except in kind of the back. And the reason for that, oh, sorry, Brian.
Oh, no, Ed, we've got another question, and you can work it in, I think. Do we have standards for marijuana? That's the next question.
Absolutely. I'll get to that in just a second. Don't let me forget it. And so during the investigative phase, that is generally law enforcement. And one of the big reasons for it is, you know, you see Law and Order and they're down there on the crime scene looking at the blood spatter next to the detective. They got their gloves on and they poke the blood or whatever. If I do that as a prosecutor, I am no longer just a bystander in this case. I am a witness to this case. It means Brian can call me to stand
tampering with evidence. We should arrest you. You're tampering with evidence. We should arrest you.
And I'm tampering with evidence. I should go straight to jail. But the point is, prosecutors and defense attorneys were not witnesses to the case. And what we say at trial is not evidence. The evidence comes from the people who were there, who have hopefully firsthand knowledge and facts about the case. Now, if I stick myself in as a character, as an investigator, as I want to be a little Sherlock Holmes, well, now I can't be impartial. I can't be a third party impartial overview of this case to make sure we get it right, to make sure we're seeking justice. I become a witness, and Brian will kick me off the case and then call me to the stand and make me feel dumb. Going back to the marijuana standards. Yes, there are marijuana standards. What we call the per se limit is 5 nanograms per milliliter of whole blood of tetrahydrocannabinol, THC, the psychoactive component in marijuana. So someone consumes marijuana and just making easy. We're just talking about smoking. It very, very quickly gets in the bloodstream, and ultimately we can conduct a blood draw and test that blood to see how much THC is in that bloodstream. Oh, marijuana DUIs is one of my favorite topics. I've got like a whole, like, basically a half-day training just on all the cool new science we're learning about marijuana. It's brand new stuff. It's super cool. I wish I had the time. But yes, there's a standard. It's 5 nanograms per milliliter of whole blood. What does that mean to you? Doesn't mean anything. Here's what you need to know. If you take 1 toke of marijuana, you're going to be over the 5 nanograms for a certain amount of time. It will vary depending on a whole bunch of factors. But the current kind of best data we have with smoking marijuana, and again, huge asterisk, the science is new, is impairment tends to be over after about 4.5 hours with many cases. Not always, but that is kind of our current best science, that what they're coming out with the scientists.
I would say, as a defense attorney, if I see marijuana and alcohol, that's a herder, because there's a lot of studies that say that's even worse. The one thing also to remember is, even though we're talking about DUI in this context of marijuana or alcohol, a DUI can be almost anything that impairs your ability to drive your motor vehicle safely, and had some interesting, and that could be prescription drugs. It doesn't have to be illegal substances. It can be legal substances that make you unsafe to drive.
Absolutely. Yeah, I've seen many people who are on prescription drugs who don't read the little thing on the bottle that says don't operate heavy machinery. Turns out a $3,500 vehicle, glass, steel, plastic, is heavy machinery, and I've seen some situations where they put themselves in a tough spot, hitting cars or driving erratically. So yeah, anyway, jumping into, okay, we've taken care of the investigation. Now charging decisions. If it's a misdemeanor case like this, so a lesser offense, oftentimes law enforcement just charge it themselves. They give you a citation. That's a charging document. Now, if they don't do that, it'll be referred to a prosecutor. That's where I come in and I review all the investigation, all the evidence, all the things for and against charging, and I have to make a decision. When it comes to charging, our burden of proof, what we have to show is that there's probable cause that this offense was committed. Probable cause simply means it's reasonable to believe an offense was committed, and it's reasonable to believe that this person committed this offense. We don't use percentages. I would never use the percentages, but some people are saying about 50.1% evidence. I would never use a percentage, but some people would say that. It's basically a reasonable belief that this offense is committed. You can't really use percentages. It's not. It's more complicated than that, but yeah. After we make the charging decision, we basically bring the charging document to a judge who has to review the charging document and say, do you have probable cause here or not? Some judges are better or worse or at critically reviewing that charging document, but hopefully, if they're doing their job, they are an initial barrier to entry after the prosecutor, of saying whether or not they're sufficient for the court to start the criminal process. And if they accept it, they set initial appearance, and then Brian, take away initial appearance.
So you can envision this breath test. This breath test is going to be at the station, and a lot of times at the detention center. And I was teasing Ed that his stripes behind him reflect some detention centers where they're trying to see if you're weaving or you're swaying on the video, because these are videotaped in most, I think almost all of them that I've seen. If you are above the legal limit, or they have other reasons to arrest you, they're going to arrest you for a DUI. If it's your first, it's possible they can release you without bond. That doesn't happen all the time. But normally they're going to say, hey, it's a $500 bond. They'll let you post that. If you have $500, depending on the severity of the offense, they also may detain you until you can see a judge. When you go in front of the judge is going to, if it's a misdemeanor, they're going to ask you for your plea, if you're guilty or not guilty, and they're going to also talk about bail. Everyone is entitled to bail, except in the case of a death penalty case, or some, if you're already an inmate, I guess, would be potentially another, maybe you're a DOC inmate that's been released and you've been arrested, but you're on a DOC hold, which is probably a whole nother presentation. So, but normally you're going to see a judge. They're going to set some conditions of release. They could release you on your own recognizance. They could have you post $5,000 bond. Don't get me started about the bail bondsman industry. That's a whole nother thing. But you're going to get a public defender if you want one. And you also could hire an attorney and appear with them at the initial appearance. So are you talking discovery or am I talking discovery first?
I think you're doing discovery.
Okay. So Montana, I think everyone's heard of Brady, the seminal United States Supreme Court case, Brady, which talks about evidence. And in Montana, we're even in the great state of Montana, as Ed would say, there's even a heightened Brady obligation on police and law enforcement and Ed. And so even though Ed is the prosecutor, the police officer who stopped this individual is collecting evidence has to give it to Ed so he can give it to me. And in Montana, not only do the prosecutors have to give you inculpatory evidence, which is things that show you're guilty, but also exculpatory evidence, which are things that show you're not guilty. And it isn't even about necessarily the guilt or innocence. It could be about the punishment. They've got to give you evidence that might make that punishment less, or that they might use to make that punishment more. And so one of the things about Montana truly is we have a little bit higher protection and constitutional protection in the disclosure of evidence. But you hear Brady all the time. That's what Brady is, essentially, is exculpatory evidence on the federal level. Montana takes that a little step farther, which is probably what we all want, right? If we're arrested, we want all the evidence. And it's great that Montana has that case law in that statement.
Yeah, and it's just about making sure that there's no surprises, right? Like, imagine a scenario where I had an officer who was not trustworthy, and she just cut out in her video the one-leg stand where she got the contradictory evidence, and then Brian never got to see it when he's reviewing it with his client. He goes, well, we don't even have an argument here. Shoot. It would be so fundamentally unfair. That's why we have Brady, and it is important. It's also my nightmare. It's what keeps me up at awake, because I don't directly know what law enforcement has. So I constantly have to hound them. Like, when I say everything, I mean everything. Give me everything so I can give a defense. I don't care if they get it. I don't care if it hurts the case or whatever. We're here to theoretically fight for the truth. So the good, the bad, and the ugly, they get it, we get it. And yeah, so I'll jump into pretrial motions. After we kind of get their initial appearance, there's some scheduling hearings and time for pretrial motions. Those are opportunities for defense to basically make arguments to the court that, hey, there were portions of this investigation that were perhaps done unconstitutionally. Maybe the officer forgot to Mirandize the suspect. Now, Miranda is way more restrictive than what you see on TV. It only applies when a person is in custodial interrogation, which is in custody to a degree associated with formal arrest, and the officer is initiating words or actions likely to elicit an incriminating response. So a traffic stop generally doesn't require Miranda until arrest. And then if it goes farther, there may be Miranda requirements there, but only if the officer's asking questions. But anyway, the pretrial motion is the opportunity for defense to raise those constitutional issues in front of the judge, and the judge gets to decide this was done correctly or this was not done correctly. If it's done incorrectly, the penalties are exclusion. So if an officer commits something that's an unconstitutional search or Miranda statements, it's gone. We lose it. The idea is we punish basically the law enforcement for doing it wrong so that they don't do it again, right? We don't want to use tainted evidence that we shouldn't have been able to get in the first place. After that point, we kind of work. Brian, were you going to jump in?
Well, I was going to say, just remember, even though we're in a DUI situation, a DUI fact pattern, we're talking about principles that apply to everything. And we have some criminal law fancy words like omnibus hearing, which is just kind of an all-encompassing hearing that we're talking about motions. But even the evidence in a homicide and even the evidence in a theft, I mean, these are all principles that apply directly. We just thought we'd limit it to DUI because that seems a little more exciting, and it's something we can talk about hopefully in the next. We have 15 more minutes, Ed.
Dude, okay, I'll keep running. Next is negotiation. The reality is a bird in the hand is worth two in the bush. I hear a lot of people grumbling about plea negotiations, and I don't think anyone who's gone to jury trial ever complains about the reality of plea negotiations. Because the reality reality is the jury trial system asks jurors to find beyond a reasonable doubt whether something happened. It's kind of society's, one of the most important questions for society, but the jurors weren't there. They don't have firsthand information. They're relying on statements and evidence from other people, and they don't necessarily know all the background of the rules because of the nature of the trial system. So it's a big ask for jurors, and just because someone's guilty doesn't necessarily mean the jury's going to find them guilty of the offense at trial. So it is really oftentimes like a business decision to, there is justice in compromise oftentimes. And a lot of times negotiations are coming down to, there's shades of gray here. I still may think they're guilty of this greater offense, but a lesser offense would still, hold them responsible to some degree. We have rehabilitation and some penalty, and they're willing to acknowledge they did something wrong. I think there's merit in that.
And the system is not set up to try every single case. And if we tried every single case, it would be doing defendants and victims a disservice. It isn't. And defendants, when we engage in negotiations and resolve cases, have a modicum of control, and that's important to people. That's really what our liberties and protections are about, is the ability to control our daily lives. So even though plea agreements seem like that's maybe not what the justice system, it might be more what the justice system about is resolving our differences in a manner that everyone can agree with.
Compromise. After we hopefully negotiate a resolution, but if we can't, we go to jury trial. You've all seen jury trial on TV and movies. I don't think we have time to deep dive it, but the burden is on the state, and I need to prove beyond a reasonable doubt that the defendant committed this offense. And that beyond a reasonable doubt is not beyond all doubt, not beyond a shadow of a doubt. It's the kind of certainty you would want in making some of life's most important decisions. Think about when you buy a house. You may have reservations, right? Think about putting a kid in a daycare. You may be nervous to drop that kid off that first day. But if you've done your research, you've checked the reviews, you've got the inspector on the house or whatever, it can be a tough decision. But if you can still make that decision, then you can say beyond a reasonable doubt, I can find this thing happened or didn't or whatever.
And I would say, as a defense, let's take it up a notch. We're talking about taking your grandmother off life support. We're talking about putting your kids on an airplane. If there's a 5% chance they don't make it to the destination, how do you feel about that?
My favorite one from a defense attorney, I love this defense attorney. He's a really good dude. He's a public defender, actually. One of his, he does on certain cases is, if you're going to jump out of an airplane with a parachute, how many frayed, missing, or broken paracords are you willing to have on that parachute before you jump out? He does the thing of like, another broken paracord, see something to be worried about. Anyway, okay. After trial, they're either found guilty or not guilty. If they're found guilty, we go to sentencing. In Montana, the judge determines sentence. We can make arguments, but the jury doesn't have to do that burden. It means they can basically just focus on the facts. It takes some of kind of the emotional aspects about it, and it also makes kind of more consistent sentencing amongst jurisdictions, at least in my perspective.
One thing I just want to throw in here, the mental health and the health of our citizens or defendants or witnesses is a major factor in the criminal justice system. And sometimes the law is not set up really well to take care of that. And even in DUIs, we have those type of situations where people are not in good mental states. And so that's a whole nother kind of diversion. But you have people taking medications for mental health issues that may impair their ability to drive and also impair their ability to be in society. And, just don't want to hesitate or don't want to leave that out, that there's a lot of dispositions that take into account mental illnesses, a variety of things in the criminal justice system.
It needs more funding. I'm just going to say, excuse me, I'm going to put a big asterisk. This is not an official statement by my office. This is my own personal opinion, but it feels like the mental health component needs more funding.
Both Ed and Brian's opinion.
There you go. Personal opinion. After sentencing, there's an appeals process, which means a higher court can review decisions and of the lower court to make sure it was done right. Again, we don't have time to really dig into it, but it's not a retry. We don't start over except in very limited circumstances in smaller jurisdictions, but generally.
You can start in a justice court or a municipal court, and the next appeal would be to the district court. If you start in the district court, it's appeal to the Supreme Court. And again, we're trying to give you a brief overview, but we have a Supreme Court, we've got a district court that takes care of felonies, and we've got a justice court, municipal court, which is most of the time where the DUIs are going to be.
And that's kind of the life of a trial or a life of a case, from investigation through sentencing and appeal. That's kind of what it looks like. And you heard the numbers of Brian's office. In my office where I was prosecuting, a line prosecutor, now I'm kind of a bigger picture. I still manage a small DUI homicide caseload. But, you know, line prosecutors, line public defenders have hundreds and hundreds of these cases at a time. They're all juggling at once, trying to keep, you know, from falling on the ground. We have 8 minutes for a couple of quick little, the most common criminal law constitutional issues. Number one, seizures. Seizures. Am I being detained? Officer, am I being detained? You've probably seen this on TV with or on the internet with so-called police auditors and things like that. That's the first thing they've got their camera out. Am I being detained? And technically, it's a pretty good question, because the constitutional protections protect citizens from law enforcement interference, basically. But not every interaction with law enforcement rises to the level where the protections, like a shield, come up and protect them. There has to be a certain point where then it applies. And that point is basically whether or not a seizure occurs. We don't use the term detained in Montana, we use seizures. And a seizure occurs when a person doesn't feel free to ignore law enforcement's presence and go about their business. So for example, Brian, hypothetically, you're downtown with friends, you're out celebrating a birthday, and you get out of the restaurant, long night, and 1 in the morning, you come out on Main Street, this beautiful evening, you're on Main Street, coming out of this restaurant, and then an officer walks up to you. Hey, Brian, would you mind if we talked? Brian, how do you feel about that? Do you feel like you can answer, yes, let's talk, or no, I don't want to talk?
I feel like I can say no thanks. Okay.
Now, what if, same scenario, except 5 officers walk up to you and they do that thing with the firearm and they click the little button off the thing holding the firearm down, and they rest their hand on their firearm. There's 5 of them, they surround you, you're alone, and they say, Brian, we need to talk.
I feel less like I can say no.
Yeah, that's gross simplification, but those different scenarios are kind of the analyses that judges will do of whether or not these seizures occur. And if a seizure does occur, if a person does feel like they can't ignore law enforcement's presence, then the officer needs to have enough evidence to justify them remaining there. Otherwise, they got to let the person go. And to start a seizure, you need what's called particularized suspicion. Objective data that someone's committing a crime or has committed a crime. It's a very low burden. It allows for temporary detainment to investigate further, to confirm or dispel their suspicion. There are different degrees of seizures. Eventually, it can become an arrest. You need more. You need that probable cause. I will cut myself off short so that Brian can jump over to searches. There's so much more of this, but we've got an hour and it is what it is.
So searches, by constitutional law, both federal and state, citizens are protected from unreasonable searches and seizures. Now, the search, a person can consent to a search, and really then there's no issue. And you have law enforcement will say, hey, do you mind if I search your car? A little public service announcement is you don't have to say yes. You can say no, and that doesn't mean anything. It doesn't mean you're hiding things. All you're doing is exercising your constitutional rights. But when you get into a search, consent, the circumstances of the search, the expectation of privacy, we have some people who actually live in their car. And it's interesting that, and I don't know that that's been litigated very much, but if you live in your car, that's a higher expectation of privacy than if this is just something getting between point A and point B. Miranda, go ahead.
I was going to say, and then did you want to jump into Miranda?
Sure. So Miranda, we tried to pick a couple topics that we thought might garner some discussion, and we got 5 minutes to discuss stuff. But Miranda's a 1966 case, Miranda versus Arizona, that essentially tells you don't have to tell on yourself. There are a couple specific issues to Miranda. If you get pulled over on the side of the road and the officer comes to talk to you, you don't have a right to an attorney. You've not been seized. You're not in custody. You're not being interrogated necessarily. Interrogated is a term of art. But if you're put in the back of a patrol car and now you have handcuffs on and they're going to ask you some questions, you do have the right to remain silent. You do have the right to an attorney. And what Miranda basically, I would say in the McDonald's version, going back to our Big Mac example, is you just don't have to tell on yourself. You've got the right to remain silent. I would say it's astounding the people who do not remember they have the right to remain silent. Silence is golden.
I've heard this said many times in this field. You have the right to remain silent. What you lack is the capacity. So that's it for our prepared stuff. If anyone has any questions, you can pop it into the Q&A. Not sure if the hosts can jump in. But yeah, we're available for questions. Thank you very much for sitting in on this. Obviously, we could talk about this all day, every day. It's, tiny little primer on it. Thank you for your patience and listening to it.
Yeah, thanks for attending. It's hard to give kind of these snippets. It's even hard to break down simple concepts. Our law-related education committee is trying to do that, to put on these seminars and be available on the website. And shout out to Anna Conley, who's the chair of that committee, and make sure this actually runs smoothly. Couple texts and emails just to make sure we're go today. So thanks to Anna. But we got 2 minutes. Questions? Anybody? Bueller? Oh, we have a question. Hold on.
Do you think we should reduce sentences? Brian, do you have an opinion about that? I think it's so nuanced.
It's interesting that the question is asked that way, because the question is usually, should we increase sentences? And one of the most important roles of a public defender is there's not a one size fits all. And it really is, what is the outcome and disposition for this defendant? And judges have a lot of discretion. I would say we don't want to take away the discretion of the judge, because most judges try to get it right. And if there are really good reasons to have a reduced sentence, the judge had the discretion to do that. So I would answer the question of, don't take away the discretion of the judge. In fact, the judge should have more discretion, in my opinion.
I think I would second that. I appreciate why there are mandatory minimums for a lot of offenses, and I think that is good policy in many ways. Sometimes there's this kind of creep of increasing those mandatory minimums, and that can maybe, we lose sight of some of the bigger picture justice if we take that kind of discretion away from the judges to take things into consideration.
One of the questions was, how many DUIs are considered a felony? I'll let you take that one, Ed.
So in the great state of Montana, no commentary. The fourth DUI is a felony. You've all heard 4 strikes you're out, right? That makes sense.
So fourth or subsequent DUI could be a felony, and then we're getting into a different sentencing structure and lots of details. One of the other questions is, why can it not be talked about if a person has a public defender assigned to them? And the public defender isn't really different than anyone else. It's just an attorney provided to an indigent defendant. So there aren't any special rules to the public defender. Maybe I'm misunderstanding the question. I apologize if I am, but
I've actually, a lot of trials I've gone to, I've had public defenders file a motion in limine, which is basically pre-trial motion saying, Judge, I don't want it to be mentioned I'm a public defender. And I think it's because sometimes there's a perspective of, well, if they've got a public defender, then my taxes are paying for their defending of their crime. And I think the fear is that could influence a jury's decision. And I appreciate that, right? Like we're supposed to say if they're guilty or not because they're people.
The question was, why can you not mention it to the jury? And so it isn't an absolute prohibition to mention it to the jury. What I would say is that sometimes attorneys are worried about what a jury will think if a person is in a socioeconomic position in life that they can't afford things. And people are proud, and people don't want to people to know that they can't afford an attorney. That people don't want to know they can't afford food, right? We have all these people who are food insecure, but you'd never know about that. So to some extent, we may ask the judge to prevent this mention of what they have a public defender assigned. In fact, when I would stand up, I would say, I'm an attorney from Missoula. I represent Mr. Johnson, and he works at McDonald's. Like, I'm not telling you I'm a public defender. I'm just telling you about my client. And so it's not a prohibition, but at times we have asked a judge to say that's not an issue. It's irrelevant to the case. We shouldn't be talking about it. Do you suggest a person refuse a BAC during a field test? I will let you have that one, Ed.
Yeah, so I will not give you a direct answer on that, but I will explain something about refusals, which I see a lot of young people make this mistake, is they don't understand that with the refusal, there are some consequences both to your license and to the jury trial. So a person who refuses a DUI breath or blood test, depending on where we're at the process, it will cause some issues with suspension of your license. However, there's this thought that, well, if I refuse, then they can't convict me of it. But in Montana and virtually every state in the United States of America, if a person refuses a breath or blood test, and if the officer has enough preliminary evidence and there's enough justification for it, the jury may infer the defendant has that diminished safety. It's rebuttable. It's not an automatic proof, but the jury gets to use the refusal in their consideration of whether or not the person has that under the influence, the diminished safety standard. So it actually can potentially come back and harm the person at trial. So there are pros and cons to both aspects of it, but I often hear, especially young people in college, think, well, if I get caught, I'm just going to refuse and it'll go away and I'll be fine. And I've seen a lot of people, young people, be burned on that. Don't feel like that's a fail-safe, because it's not under the eyes of the law in Montana.
I mean, from a defense perspective, again, the idea you don't have to tell on yourself. You are providing information. You are providing evidence. And I mean, there's no one size fits all. I can't, as a defense attorney, advise you to do something all the time, because there's going to be a circumstance where all the time doesn't apply. But you have the right. You've got the right to refuse. There are some consequences. You have the right. I've got one question here, and then Ed, maybe you can read one from Gail. But one of the questions was roughly what percentage of Montanans can afford private defense counsel? I would say that number is going up and up. I've heard anecdotally that some attorneys in like Bozeman are charging $350 an hour and up. I mean, Ed's just telling me right now that may be low. And so there's a shortage of attorneys, I would say, in the private sector. We have a shortage of attorneys in Montana in general. And the supply and demand has spiked some of those numbers. I would say more and more today, people cannot afford private counsel. So,
and it means it's more burden on the public defender system to pick up the slack, and that there are consequences to that. I'll be sure. I'm not just saying this because Brian's here. I really like the public defenders I've worked with by and large, because they have more experience than a lot of the private attorneys, and they understand the system, they understand the norms, they understand trial procedure a lot better, just because of the sheer number of reps. It's like you go to the gym, more times you lift the weights, the better you get at it. And so the public defenders means we can have, quite frankly, shorthand, more blunt, honest conversations and probably get to the same place without exchanging 47 emails and doing 10 laps around the block. It sounds
you may not be able to answer this one. Ed,
yes, that sounds like a question about a specific case. I can't answer that. I have no idea the details of it. There's a million factors in play there. If you have a concern about a specific case, it's probably best to identify who the actual prosecutor in the case is, and maybe reach out to that office and see if you can have a conversation with them, because it's complicated. Just because it's a prosecutor case doesn't mean our office has the ability to stick our hands in and get involved.
One of the things I would say is, from the defense perspective, we are all the time asking prosecutors and judges to exercise their discretion. And there are very few obligations that don't have some discretionary component to it. So it's probably really hard for us to answer a question as far as that obligation, in my opinion. The last question is victim rights, impact statements, pecuniary losses. There are some Montana laws that protect victims. Ed can probably tell you, the people who are impacted from the other side probably call him a lot. The struggle I have in the defense attorney is sometimes, are we putting the victim's rights over the defendant's rights? And this is where we're talking about putting someone in jail or curbing their liberties. And then the question is, the old adage, it's better to let one guilty person go than put one innocent person in custody. And if we are elevating victims' rights over defendants' rights, that's my concern. So, Ed, one of the questions is, what about changing a judge?
That is possible. It's limited. It has to be filed, I think, within 10 days of the charging document.
In district court?
In district court, excuse me. It is possible. It's not done very often, by and large, across the state.
We have a system of elections, which I can agree with or disagree, but it is important about who we elect for judges. They play a super important role. And there are some ability to change judges or substitute judges, but I would say this is one of those things we as citizens have to get right, and we need to all be involved in. So, 1, return your jury summons, and 2, vote. That's our public.
I'm going to add a little tag onto the victims' rights stuff as well. So there are legal obligations on the prosecutor's office to and the law enforcement to kind of make sure that the system has in place notification to victims of offenses, and that they're advised of kind of certain milestones in the case, as well as afford the ability for victims to provide victim statements to the court for sentencing purposes, as well as pursue restitution. Now, as a prosecutor, it's oftentimes put me in a weird spot because I don't represent a victim. And it feels a lot of times like I feel for them. I want to help them. And I can help in some ways hold their hand through the system and explain what's going on. But at the end of the day, my duty is an ethical duty to seek justice. I'm not a representative for the victim, so I do have some limitations on that.
I want to thank everybody. An hour's not a lot of time. I mean, I think, Ed, I speak for you as well. We love doing this. We love talking about our professions. We're very passionate about it. You could get us, just buy us a drink sometime. We'll talk to you all about it.
Thank you very much. I don't think we got time for any more questions, and really, really appreciate it. So,
yeah, thanks for being here. It's important to learn about these topics. So have a good night, everybody.
Thank you.